WNYC Studios is supported by Wise. Wise, the smart way to manage the currencies you need around the world. With the Wise account, you can send, spend, and receive in up to 40 currencies with only a few simple taps. Be smart. Get Wise. Download the Wise app today. Terms and conditions apply. WNYC Studios is supported by Odoo. When you buy business software from lots of vendors, the costs add up and it gets complicated and confusing. Odoo solves this. It's a single company that sells a suite of enterprise apps that handles everything from accounting to inventory to sales. Odoo is all connected on a single platform in a simple and affordable way. You can save money without missing out on the features you need. Check out Odoo at odoo.com. That's odoo.com.
It's the Brian Lehrer Show on WNYC. Good morning again, everyone. And yes, live parade ceremony coverage starting at 11:45. I think we will get to hear Alicia Keys sing, which song did they say? New York State of Mind, one of those. And we'll hear the mayor present. We'll hear the Knicks who are going to speak. So that parade coverage starts in about 25 minutes. Meanwhile, the Supreme Court is now issuing decisions on major cases as we head toward the end of June and into the first days of July, as each year. And we've recruited some of our most diligent legal eagles to stand by and watch out for those cases, which are released mostly on Thursdays and mostly at 10 a.m. And some of the major cases that we're watching include birthright citizenship, temporary protected status, transgender athletes, and mail-in ballots. There are also two major cases concerning the Second Amendment, and the Supreme Court did issue a ruling on one of those cases this morning. It's called United States versus Himani. The court addressed whether denying gun ownership rights based solely on recreational marijuana use violates the Second Amendment. So joining us now to discuss how the court came down on this, what legal precedent it might set, and to preview at least the other Second Amendment case in front of the justices is Kate Shaw, professor at the University of Pennsylvania Carey Law School, co-host of the Supreme Court podcast Strict Scrutiny, and a contributing opinion writer with the New York Times. Kate, always great to have you on Decision Days. Welcome back to WNYC.
Hi, Brian. Thanks so much for having me.
So let's cut right to the chase. Does the Supreme Court think that recreational marijuana use is reason enough to deny somebody a gun permit?
It does not, and it does not think that unanimously. So this is one of the rare cases in the big kind of end-of-term rush where the justices basically agree. So as you said, this is just about an hour ago, the opinion in Himani came down. And again, the court basically unanimously, there are a couple of concurring opinions, but they all agree with the bottom line, which is that this law that prohibits gun possession by individuals just because they're users of marijuana is unconstitutional under the Second Amendment.
So is this a coalition of justices who want to support people's rights who use cannabis and justices who want to support people's right to own guns at almost any cost?
And this is the sort of unusual convergence of those, potentially. I mean, I think this is actually, given how expansively the court has read the Second Amendment and its right to keep and bear arms in recent cases, really for the last 2 decades, it's hard to see this case coming out any other way. If you have this very central constitutional right, it's hard to see the government being able to infringe it on the basis that it did here. So basically, this is a federal law that has lots of, it prohibits people from possessing guns in a bunch of different categories. And some of them the court has actually, even in this new Second Amendment era, upheld. So a law, say, prohibiting individuals convicted of domestic violence crimes from possessing firearms. But here there's a provision that prohibits the possession of guns by individuals who are unlawful users of controlled substances. And Himani, in this case, was somebody who had a gun and admitted that he used marijuana about every other day. And that was the entire basis for the feds charging him with possession of a firearm. And the court basically said, under this historical method that we use to decide whether gun restrictions can survive, but also given the kind of contemporary status of marijuana, right, which is, of course, decriminalized in many places, and many Americans are regular users of marijuana, there isn't a sufficiently strong government interest in keeping marijuana users from having firearms, nor is there real evidence that regular users of marijuana are very dangerous as gun owners. And for those kind of both historical and practical contemporary reasons, this basically unanimous court strikes the law down.
Right. Some of the particulars of this case, which I haven't followed, but from what I've read, and you can correct me if any of this is wrong, are that in 2022, Ali Hamani, who's a Pakistani-American citizen, had his Texas home searched by the FBI for suspected terrorism-related activities. He cooperated with the agents, pointed them to a firearm that he legally owned, as well as telling them that he used marijuana every other day. That's the quote that I saw, every other day. And so the government attempted to prosecute him under a law that makes it a crime to be an unlawful user of a controlled substance. So there was, I guess, the Texas context is that they don't have legal recreational marijuana, or didn't in 2022, and that was part of the hook.
Yeah, and it is still unlawful for the most part under federal law, despite the decriminalization in many places. So he did admit to use of marijuana, and you said, Brian, correctly, there was this kind of terrorist investigation backdrop, but none of that resulted in criminal charges. The only criminal charge was based on his having the gun, which he had lawfully, and admitting to this every other day use of marijuana. And the court basically says, well, it sort of puts aside the kind of larger context of this maybe terrorism investigation and said the charge itself is just about this unlawful use. And, it uses this historical method. It's kind of an interesting opinion where the court says, well, in order to sustain, to uphold a gun law, the government defending the law has to show that it's consistent with the tradition of regulating firearms. And what the federal government had pointed to here was these old laws targeting, quote, habitual drunkards, and said, well, government has targeted people for intoxication. That's not really different from targeting people who are unlawful users of marijuana. And Gorsuch, who writes the majority opinion, basically says, no. So first of all, talking about kind of the history of regulating intoxication, he basically says at the founding, everyone drank all the time. So he actually quotes scholars saying things like, John Adams took a tanker of hard cider with breakfast, and James Madison consumed a pint of whiskey every day.
This was in the opinion today?
In the opinion, yep. Drawing on scholarship about the kind of drinking habits of the founding generation. And I mean, to be clear, like water wasn't that clean then. So sometimes alcohol was actually a better, safer thing to consume. So there's reasons people drank so much. But basically the point Gorsuch is making is these laws were targeting serious drunkenness that really incapacitated people. And that's not necessarily the case with an every other day user of marijuana. And also those drunkards laws were about things like civil confinement, not disarmament. And so the historical analog just doesn't work for the court. And then there's the kind of contemporary backdrop, which is, again, lots of state level decriminalization. The feds haven't totally decriminalized, but they have moved away from enforcement, and they have downgraded some marijuana from Schedule 1 to Schedule 3. And given that, like millions of Americans regularly use marijuana, the federal government just can't say habitual users, even if it's, unlawful under federal law, are so dangerous that that use can be used to extinguish their gun rights, which the court, its majority, thinks are really kind of central core constitutional rights protected by the Second Amendment.
But in the ruling, from what I saw, Justice Gorsuch emphasized that this decision is, quote, a narrow one.
Yes.
We do not address efforts to ban addicts or those presently intoxicated from possessing a firearm. What's the distinction he's trying to make?
Right. So this is just this kind of the admission of unlawful use, which is the sole basis that the federal prosecutors used. That itself is not enough, but that doesn't mean the federal government cannot prevent people who are currently under the influence of illegal drugs from possessing firearms. And the kind of question of addiction sort of raises potentially distinct constitutional questions because criminalizing status as opposed to conduct is something that is at least constitutionally suspect, like if you have an addiction. But the court basically says we're putting those to one side and just narrowly ruling that this unlawful use prong of the federal law, that can't be the sole basis for disarming someone or for prosecuting them for unlawful possession of a firearm.
Interestingly, also, the majority points out that the federal government recently moved some marijuana products from Schedule 1 to Schedule 3, meaning categorized as less dangerous controlled substances, and it uses that against the government's own argument. But in a footnote, the court explicitly says the felon in possession ban and the ban on people committed to mental institutions, that is, gun ownership ban if you're a felon in possession or if you're committed to a mental institution. Those are not in doubt. So can you explain the felon ban issue for us and why the court decided not to touch it this time, or even refer explicitly, affirmatively to the fact that it's not touching it?
Well, I think it's right that it's not touching it here. The court says that explicitly, but I wouldn't say it's not in doubt because that's another provision of law that says individuals convicted of felonies are categorically prohibited from firearm possession. And there have been a lot of challenges kind of making their way up to the Supreme Court and various federal district courts and appeals courts by individuals convicted of things like nonviolent offenses who are challenging their prohibition from firearm ownership or their convictions for firearm ownership based on their previous convictions for other like nonviolent offenses. And I think the court, I don't know how to kind of game out what the court would likely do with those challenges when they're before the court. Lower courts have gone different ways. I mean, this court is really committed to the Second Amendment, and I think might be willing to say that at least some kinds of crimes, conviction for certain kinds of crimes should not render you ineligible from gun ownership. And so I think the court was just saying this case of its own force doesn't invalidate any other, conviction because somebody's a felon in possession. But I wouldn't say that those laws are, totally free from doubt when the court does have a chance to decide them.
Interesting. And listeners, we can take comments and questions for UPenn law professor Kate Shaw, also co-host of the Supreme Court podcast Strict Scrutiny and a New York Times contributor. And it can be about this particular case that the Supreme Court ruled on this morning, or it can be about other cases. We have a few minutes before we go to parade coverage. And I mentioned at the top some of the big ones that we are still expecting. And here we are on June 18th. The end of the term is supposed to be the end of the month. And, we don't have it yet on birthright citizenship, temporary protected status, transgender athletes, mail-in ballots. We're still expecting all of those. Maybe, Kate, they just didn't want to rain on the Knicks parade, literally, by doing a super heavy release today, even if they have it? Or do you think that's reading too much into the timing and their awareness of what's going on in Lower Manhattan?
There's a bunch of New Yorkers on that court. You got Kagan, you got Sotomayor. I mean, people who I guess not as many as there used to be, but it's a strong New York contingent on the Supreme Court. So maybe they did want to give everybody the space to focus on this wonderful celebratory day for the city. But they really are backloading the big opinions, and they always wait until the last week or two of June to issue the most consequential and the most decisive opinions. And there's a reason for that. The justices are going back and forth with their draft opinions. The dissents are responding to the majority opinions. Sometimes they are tweaking or refining their claims or arguments in response to their colleagues or adversaries on the bench. And so that they're just not ready. They're not like holding them and releasing them sort of piecemeal for no reason. They just are actually finishing the opinions. But it does feel like an unusually backloaded kind of final stretch of the court's term.
So listeners, anything for Kate Shaw at 212-433 WNYC, just so I remember to get the phone number out. For those of you who don't have it on your speed dials, 212-433-9692, call or text. Here's a text. Listener asks, wasn't the gun ownership and drugs the law under which Hunter Biden was convicted?
That's a great question. And I actually think that the focus was the addict as opposed to the unlawful user provision. Remember, we talked about there's a unlawful user currently intoxicated or addicted. And there were Second Amendment arguments that were floated in that case. So I don't think that, as I said, that kind of like this addict provision is totally free from constitutional doubt. But of course, that's a case that the Supreme Court never weighed in on. So that the fact that a lower court, whether there's a guilty plea or a conviction in a lower court, does not necessarily mean the Supreme Court would ultimately agree with the way the statute is being used. This is just the case that kind of came all the way up. But I think I could be misremembering, but if I'm not mistaken, it's the slightly separate, although very closely related provision that was at issue with Hunter Biden.
Here's an NBC News version of covering the ruling this morning. Supreme Court rules government cannot restrict gun rights for casual drug use. The justices cast a blow against a federal law that bars users of illegal drugs from possessing firearms. President Joe Biden's son, Hunter Biden, was convicted under the same law. So maybe it was a different aspect of the same law is what I think you're suggesting, but that is making it into the headlines. I see a Fox News one that also refers to Hunter Biden's case relevant to this ruling. So interesting.
Very interesting.
Justice Ketanji Brown Jackson joined the majority, but then wrote separately to say the whole Bruin framework, gun rights framework, that's combing through founding era laws, like from the 1700s, to evaluate modern gun regulations is unworkable. Can you explain what Justice Ketanji Brown Jackson was getting at?
Absolutely. And this is a point that she has made in other cases. So as I was saying, this kind of directive to look to history, directive to courts to look to history to decide whether a current gun regulation is constitutional, she thinks is just a fundamentally kind of doomed errand, and that it's fatally flawed in that it kind of ties current regulators today to the conditions of the past where guns looked really different, the kind of violence that gun owners could commit looked really different. Obviously, mass shootings were neither the fact they didn't happen, the guns that could have committed them didn't exist. And so to suggest that regulators are so constrained in what they can do to respond to this epidemic of gun violence by what regulators of the past did, she just thinks is like a profoundly misguided endeavor. And Gorsuch tries a little bit to respond to that in the opinion for the court, basically saying, no, we're not requiring there be some perfect historical twin in order to uphold a current gun regulation, but we're asking in broad terms what regulations of the past looked like, and also why kind of government, state or local or federal in the past decided to regulate in the way that they did. And that was the reason there was this kind of parsing of the differences and the similarities to these kind of habitual drunkards regulations. But she basically says that this case, Bruin, which had to do with the New York regime for requiring a license to carry a firearm and actually showing some need for that license. And the court struck that regime down and basically said every state has to basically license individuals who want to carry firearms subject to some very narrow exceptions, kind of a parallel to the federal ones that we were just talking about, individuals convicted of felonies or committed to, say, mental institutions. But otherwise, if you want a firearm license under this Bruin case, you get one. You need to be given one by your state. And she just says that the method, not only the outcome in that case, but the method that it directs courts to use is fatally flawed. And so she goes along with the outcome here, and maybe that's the kind of, different justices agreeing with the outcome for kind of different reasons, a rationale, but she is not willing to basically keep quiet about just how misguided she thinks the entire enterprise of the court's gun cases really is.
David in Stockton, New Jersey has a question about this. Hi, David, you're on WNYC.
Hi, Brian. Thank you for taking my call. My question for the professor is this. When you get a background check now to buy a firearm, you have to fill out an ATF form. And on that form, it specifies that marijuana use is illegal under federal law and then asks you if you are a user or not. So being that it's a crime to falsely fill out a federal form, before the ATF issues new ones, what is somebody to do if they're going to do a transfer?
That is a great question. I presume that ATF is now going to redo its forms because this is no longer going to be a disqualifying box check. So, I am a little bit reluctant to dispense legal advice live on air, but I guess I would probably say to make a note that references Hemani and that says, under the court's current cases, the possession of, or the regular use or unlawful use is the language in the statute, of marijuana is not disqualifying for firearm possession. If you even can check that, if there's a way to provide some kind of notation. But I guess I would say if it's possible just to wait for the ATF to produce some new forms, that might be the safest. But certainly the way a decision like this gets implemented is it just trickles down through federal regulation and paperwork. But the caller is right about the kind of underlying thrust of the question, which is that box no longer under this ruling disqualifies you from, lawfully possessing a firearm under federal law.
Thanks for the interesting question, David. Jessica in Manhattan, you're on WNYC with Law Professor Kate Shaw. Hi, Jessica.
Oh, hi. Thank you for taking my call. It's really off subject, but when I heard the discussion of felonies and gun ownership, it reminded me of convicted felons, I believe, are not allowed to vote, which to me has always been a real problem. And I wonder if the professor is aware if there are any cases about that, or does she think it's worth launching a case like that? It seems to me that people who are convicted of felonies are really denied the chance to vote, and forever. I mean, Florida might have done something about that, but I just wonder where we are with that in the country.
I think that's state by state, right, Kate? In different states, if you committed a felony but you served your time, you get your right to vote back. But how would you answer the caller's question?
Yeah, I think it's a great question, and it does highlight this distinction. So you're totally right, Brian. It's very much a state law, sort of state by state. Florida had one of the most extreme felon disenfranchisement laws in the country. The Florida voters actually, enacted a provision that provided broad reenfranchisement, but that hasn't been implemented fully. But there are states where you actually, even if you're currently incarcerated, can vote. So there's actually an enormous range in terms of what felon disenfranchisement looks like across the states. There have definitely been constitutional challenges. If the right to vote is fundamental, it feels as though a state law that forever bars you from exercising that fundamental right might be unconstitutional. The Supreme Court in a case called Richardson versus Ramirez in the 1970s basically shut down those arguments. But there are other creative arguments that have been made and that have succeeded in various ways in the lower courts, challenging aspects of disenfranchisement. And then there have been, efforts to use democracy and have the voters actually act to provide broad restoration of voting rights. So but I think that the caller identifies something really profound, which is the court feels much more protective of the right to own a gun than the right to vote in this moment. And I think that is quite misguided, but I think if that was a kind of a subtext of the question, I think that is really insightful and an accurate characterization of where. Yeah, and it is, I think, where the court is, and to my mind, it's profoundly problematic. The court has been underprotecting the right to vote in all kinds of ways, not just when it comes to disenfranchisement, and I think arguably overprotecting gun rights against reasonable regulatory efforts to, enact common sense gun restrictions.
There is one more Second Amendment case still pending this term called Wolford versus Lopez out of Hawaii. I see that gun rights challengers have nicknamed the state law there the vampire rule. So let's see if I got this right. Hamani is about who can have a gun, and Wolford is about where they can carry it?
Basically, and the vampire reference is about, I guess, an invitation. So this is Hawaii has a law that basically requires. So if you are a property owner, the default is that gun owners cannot carry their guns on your private property unless you have affirmatively provided permission to them, like put up a sign that says, you can carry here. But the default is that gun kind of carriage on private property is prohibited unless the owner affirmatively acts to allow it. And so I guess the vampire reference is that there needs to be an invitation in the way that some vampire lore suggests vampires need to be invited in. Gun owners need to be invited by property owners to carry their guns on their property. And Hawaii just says it's just a default that says you can't carry on people's property unless those people are comfortable with it. But gun owners say that this is a law that is hostile to gun owners and to the Second Amendment. And the court seemed quite receptive to the challenge when it heard oral arguments in the case. So I suspect that this case, is very different from Hamani, but will also come down on the side of gun owners and broad Second Amendment rights.
The next Supreme Court decision day is scheduled for next Thursday. But before you go, on a kind of broader trend that you've cited, I see you're noticing a trend between the lower courts and the Supreme Court. The Supreme Court seems to be deferring to Trump and undermining lower courts a lot, while lower courts are challenging him more. Explain.
Yeah, I think that one of the big trends of the last year and a half has been the lower courts constraining the president, right, acting as a bulwark against presidential overreach, whether we're talking about violations of statutes or sort of exceeding constitutional authority. And that's when it comes to spending or firing or renaming federal agencies. The list is, I think, very long of presidential overreach. And lower courts, again and again, have ruled against the Trump administration. And yet when those cases make it to the Supreme Court, typically on the shadow docket, Trump prevails, often without any real reasoning. So, I think there's an interesting display just over the weekend when a lower court ruled that Trump's name needed to come down from the Kennedy Center, and the administration was unsuccessful in getting the appeals court to block that ruling from going into effect. And so it seems that name has actually come off, although if folks watch this over the weekend, there is like a tarp basically covering the front of the building. And so it's not actually clear that the name has come down, although the lawyers for the administration say that it has. And that's a case where the Supreme Court didn't intercede to essentially assist Trump. But I think there was some thinking that it might over the weekend, and it in fact did not, maybe because they're busy churning out the final versions of these opinions. But I think we'll see if that trend holds in the big cases kind of yet to come, in particular the ones involving the president's power to fire officials like a commissioner on the Federal Trade Commission or a governor on the Federal Reserve Board of Governors.
Kate Shaw, professor at the University of Pennsylvania Carey Law School, co-host of the Supreme Court podcast Strict Scrutiny, and a contributing opinion writer with the New York Times. Thanks so much for coming on today. We always appreciate your analysis of what the court and the courts are doing.
Thanks so much for having me, Brian. And now on to the parade.